All right, so welcome to our tutorial for week 6, the part that we're going to do in Toowoomba. And today we're going to talk about two different chapters. So we're going to go back and do some from chapter 8 and maybe cover also some of the stuff from chapter 9. So we're talking only about contracts. We're going to start on page 238. Question 7 on page 238. Always remember that I've given you the questions and their answers already on Study Desk. You just need to go and download those files I've talked about. That's not what's important here. We want to unpack those answers so that if I change the question a little bit, you can pick on the change and how that changes your answer. This question says, a contract, this is for purchasing a car, it has this clause. In the contract, there's this clause. If you are not completely satisfied with this car, return it in good condition within 7 days, and we will give you your money back. It's a money back guarantee. The question, is this a condition precedent or a condition subsequent? So if you want to know more about precedents and subsequent, let's look at page 226. Just a quick revision on condition precedent and condition subsequent. So it says a condition precedent, page 226, is a clause or a term in the agreement stating that the agreement doesn't become a contract until the happening of a specified event. So you're not going to get to the contract until this happens first. For example, subject to finance. Okay, if there's an agreement and you find that we say subject to finance, okay, or subject to solicitor approval. Okay, now condition subsequent, on the other hand, will terminate the contract. So there is a contract and will continue to be a contract until something happens and it ends the contract. Okay. Example, the occurrence of a particular event will give the parties a right to terminate the contract. So, if we look at this example, if you are not satisfied, we will give you your money back. What's the event here? The event is always the same. The event is what? Regardless whether subsequent or precedent. They're talking about an event. What's the event? This is the event, right? If you are not completely satisfied with the car, that's the event. Something is going to be triggered. If this happens, what? We will give you within 7 days, we will give you your money back. So is there a contract already in existence or not? Yes? So if you sign the contract, that brings the contract into existence. So this must be what? A condition subsequent. So we're going to have the contract is operational. If this event occurs, we will give you your money back, so it must be a condition subsequent. All right. So it's a condition subsequent, and this is why. All right, question 8. Again, page 238. On March the 7th, Brandon sent a letter by express courier to Sydney, offering to buy fabric from Stephen. At the foot of the letter, he added, please write and return by express courier, just like I did, whether you accept my offer. Okay? So he made an offer. And he also said to Stephen, I would like you, if you want to accept, to send that acceptance this way. The letter was delivered on the 8th of March. Stephen wrote accepting the letter. So far, so good. No issue. However, instead of giving the letter to the express courier, as Brendan asked him to do, Stephen sent it by post. An express letter would have arrived back in Melbourne on the next day, the 9th of March. But because it was by post, it did not arrive until the 12th. On the 15th, Brendan replied to Stephen's letter saying that he had bought his requirements of fabric elsewhere. Stephen claimed that there had been a breach of contract, advised Brendan as to his legal position. So this is thus the first element of the existence of a contract. We're simply asking whether there's an agreement or not. No intention, no consideration, just agreement. In particular, whether there's an offer and acceptance. So, what did we say about offer and acceptance? One of the most important concepts in relation, or rules in relation to acceptance, is that what? It has to be so this is what we covered in Springfield, and I'm not sure if you are actually doing your homework or not. Okay, 93 hours, folks. 93 hours. So you have to do some study on your own. All right, let's look at page 227. So sometimes you just get lost between the pages. Here we go. Just bear with me a minute. Here we go. Rules as to acceptance. There are rules as to offer, and there are rules as to acceptance. Okay. One of them says that it must be strictly in accordance with the terms of the offer. What was one of the terms of the offer in this question? By express courier, right? Brendan stipulated as one of the terms of his offer that if you want to accept my offer, you have to send that acceptance through express courier. Yes? So what happened here? Stephen decided not to follow that express requirement. So was his acceptance valid? Because one of the rules, it has to be strictly in accordance with the terms of the offer. What do you think? If I tell you that I need that acceptance to be through express courier, so you decide to do it through something else, okay? Would that still be a valid acceptance? So when you come to this part of the course and you start your analysis on the existence of a contract, especially the first element, it's this kind of analysis you have to go through. Offer, acceptance. So in your notes, the ones I've given you, you'll find that there's a list of the rules for offer, list for rules of acceptance. When you're doing your planning before you write your answer to the question, that's what you are reading. So the first issue that we have, and that's how you need to structure your answers in the exam. The markers are going to be looking for the legal issues. If you fail to recognize or spot the legal issue, you are not going to get any marks for that part. So the first issue, whether acceptance was valid. And the second issue, whether the revocation was effective, because Brendan sent the letter on the 15th saying, I withdrew my offer. So Brendan specifically informed Stephen that he wished his offer to be accepted by express courier, where the offeror, who's the offeror here? Brendan, thank you, specifies a special or particular method of acceptance. It must be followed exactly. We saw that as one of the rules for acceptance, which are on page 227. Stephen failed to do this. He accepted through regular post. Therefore, his acceptance may not be recognized as an agreement between the two parties, i.e., his acceptance is not valid. Okay. There's a problem still, which is this. Had Brendan stated that the offer would only be accepted on receipt by him via express courier, because there's something called the postal rule, you see. Even though Stephen's acceptance is not valid, it would be made the minute he posts the letter. That's what we mean by the postal rule. Regardless what time it arrives at Brendan's. Because Brendan didn't stipulate to remove the effect of the postal rule, so you should have said something like, acceptance valid only on receipt of your reply. Regardless then whether you send it by post or you send it by express courier, it doesn't matter. I will not accept that acceptance until I get it. You can stipulate that in your offer as one of the terms. That would have excluded, of course, this issue. All right. So in the exam, you will have one page. Just on top of that page, you will have issue 1. And always express that issue as a question, whether acceptance was valid. Okay? There's many ways you could write it, right? Whether acceptance of the offer made by Brendan, whether Stephen's acceptance of the offer made by Brendan was valid, whatever. But you're talking about the acceptance and its validity. Then you go on and leave space and go to, because sometimes you come back and remember something and you want to write it. Okay? The second issue, so this could be a 10-mark question in the exam. 5 marks on the first issue, 5 marks on the second issue. You fail to spot the issue, you get 0 for that part. So if you have a question that says 15 marks or 20 marks, you know, reasonably, there's more than one issue, right? The second issue, whether revocation was effective. Applying the postal rules, Brendan's offer was made on the 8th of March, when received by Stephen and accepted that same day when posted by Stephen. For Brendan to successfully revoke his offer, the revocation must have been received before he posted his acceptance. Since the revocation did not occur until the 15th of March, such termination of the contract by revocation would not be permissible under postal rules. So of course this is not the end of it. After that you have to conclude. So in conclusion, you're going to say what? Is there an agreement here? One step at a time. Is there an offer? Is there a valid acceptance? Come on! Look at the first issue again. We're saying whether acceptance was valid. What did we come up with there? What did we say? Was there a valid acceptance or not? People?
No, because we didn't send it back.
Thank you, Tim. God bless you. So we said acceptance is valid only if it meets all of these rules. One of these rules is that this acceptance must be strictly in accordance with the terms of the offer. One of the terms of our offer was what?
It had to be delivered.
Brendan said use express courier. Did Stephen use express courier? So then his acceptance is not valid. That's the first conclusion. What is the second conclusion? Was the revocation, of course, once you say that there is no valid acceptance, that means there is no So offer and acceptance will give you what? If you have a valid offer and a valid acceptance, you get what? No. Offer plus acceptance equals, starts with an A, agreement. Thank you. Once you get the agreement, you have to get intention. Once you get intention, you get consideration. Then you can say there is a contract. A simple contract exists. You see how you have to take it? What about the second conclusion? Was there any valid revocation in this case? Assuming that there was a valid acceptance, which is counterfactual in this case, the revocation of the offer by Brendan would be ineffective. Why? Because the poster rule was not displaced. If he said in his terms that the poster rule doesn't apply, meaning I will not accept your acceptance until I receive this express courier or whatever form that you're going to send to me, then that revocation would have been valid. Okay? So you have to conclude. That's the key point. All right. Let's look at something else. We don't have to do everything. It's just to give you, the discipline of how you want to approach this in the exam. Let's go on again with this offer and acceptance analysis. An insurance company, question 9, page 238. An insurance company advertised an invitation to the public to subscribe for shares. Okay? Grant applied for 100 shares, and he did so through mail. So the shares were duly allotted to him, so he was given a certain amount, and the letter of allotment was posted. So the insurance company said, we gave you 100 shares, and the letter was sent to him to inform him of that. As always, there's a problem. The letter got lost in the mail and was never received by Grant. Okay. Nothing further was heard from the company for several years, until eventually, of course, they demanded payment for the shares, $400. Grant claimed that he was never a shareholder and refused to pay. Advise him. Advise Grant. As always, you start from the top, whether there's an agreement, and then intention, and then consideration. Today we're going to look only at agreement. Is there an offer? Is there an acceptance? Is there an offer in this case? Yeah. So in the exam, I don't expect to say to me, there's an offer in this case, full stop. So I don't know what you're talking about. Where's the offer? You have to explain to me. I don't know. Where's the offer?
The insurance company advertised an offer, a public offer that subscribed.
Okay. So Tim is telling us that the offer is this invitation, right? It's the invitation to the public. It's an advertisement. What did we say about advertisement generally? When I advertise something in the newspapers, do you think I intend to be legally bound? Do you think that the offer is intended for you to accept? Okay. So you have to go back and revise, because we said from Carlyle that the general rule is that you don't intend to be legally bound. So if you give an advertisement, that's only an invitation to treat. It's not an offer. There's not enough information in it to make it an offer that I can accept. All right? So that's the first thing you have to tell me. Remember, we're doing ILAC. So that's the issue. The first issue, whether there is an offer, a valid offer, the law. So you start saying an invitation to treat is generally not an offer. Okay? However, sometimes it could also be considered an offer depending on the level of detail that shows an intention to be bound, between parentheses, Carlyle underline. Yes, Tim.
I would argue that in this case, because Grant can send in a letter through the mail to apply for the shares, then that is an offer.
Okay. So again, that doesn't excuse not saying whether this is an offer or not. So you have to spot the issue. I'm not telling you that this is the answer, but I need to see you struggle. I need to see that you should see that the facts are giving you attention.
Because if it wasn't an offer, then Grant would have to contact the insurance company to get the offer.
Correct.
But because he can just apply immediately, then it is an offer.
Okay. So he's saying what happened here is that Grant sent this mail applying for 100. What is the information in this transaction? What's the information in this communication?
He actually did apply for the shares.
Okay, what else?
That they did allot them.
Yeah, but there's another piece of information you get out of that.
It got lost in the mail.
No. So he wants to buy shares and he wants to buy 100. That's it. Out of all of that, you can tell that he wants shares, he wants 100. Do they know that without that? They can't tell until he does that. Until he mails this, they don't know. So again, going back to your point, the amount of the shares, which is also the price of the shares, the total, is not known until he sends that out. So which one of these two do you reckon has more information, more specificity, more fleshing out to be considered the offer in this case? So you can argue. I'm not telling you. Remember, folks, law is not about right or wrong. It's always going to be gray. Your job is to show me that I can see the problem. That's all. Whether you say the offer is from Grant to the company, or you say the offer is from the company to Grant, I don't care. But if you just say that, so you start by saying whether there's an offer, and the second sentence, the advertisement by the company is the offer. That's not good enough. So you have to explain why. Why do you think that? What is an offer? Why do you think that's an offer compared to this? Okay? If we go with Tim and we say that the advertisement in this case is an offer, then what's the acceptance? The Grant, this mail showing that he wants 100 shares would be the acceptance. If that's the offer, that's the valid acceptance, we have an agreement. The other theory, you go with Damien, if you say that Grant made the offer by that mail, because the first one is simply an invitation to treat, so the offer is going to go from Grant to the company with the 100 shares. The application is the offer. Where is the acceptance?
The shares were allotted by the insurance company.
The allotment, yes, the allotment is the acceptance. But one of the things you have to do with acceptance is what? The rules tell us that we have to do what? Which one is relevant? I have to point it out?
Must be communicated.
Thank you. Thanks, Tim. So the second rule says it must be communicated to the offeror. Who is the offeror on Damien's theory? The company or Grant? Grant. So, must be communicated to Grant. Orally, in writing, or by conduct. Yes? Okay, let's look at the facts. One step at a time, so that you can get it right. So, they mailed this. It was posted. There was a letter posted. So far, so good? Huh? The letter got lost in the mail. So, where are we going with this? What's the relevant rule? We call it the postal rule. Yes? The postal rule, everybody? The postal rule says what? Page 231. So the postal rule the postal rule says where the parties contemplate the use of the post as a medium of exchange of promises. Of course, on the facts in this question, we're not told what the company wanted. We're simply told that they made this advertisement. We're not told in the advertisement whether it's stipulated for express courier or for post or anything. So we assume that they left that open. You can send it by post. Excuse me. The offeror must have contemplated and intended that the offer be accepted by the act of posting. Who's the offeror again? Grant. Grant sent a letter by post. Did he say anything in the letter about how the acceptance should be related to them? They simply said, I want to buy 100 shares. Here's my address. So it's left the default position, the postal rule applies. So it says, in which case the rules as to the time of acceptance change. So acceptance is not when you actually receive the letter, it's when the letter is posted. So when the company wanted to accept Grant's offer, they posted the letter. The act of posting the letter is acceptance. By the postal rule, we say that this act of posting is communicated already. It was not communicated. Grant doesn't know about it, but it's communicated because of the postal rule. Unless Grant, when he sent his offer, said the postal rule doesn't apply, I will accept, or your acceptance is valid only on receiving your letter. So then when the letter gets lost, you don't worry about it because I haven't received it. But because of the postal rule, which is the default rule, the acceptance is valid once the letter is posted, regardless of whether Grant receives it or not. All right. So Grant could argue that the insurance company was simply advertising its shares to public, which should thus merely be viewed as an invitation to treat. Okay. The contract concerning the shares would be complete upon the insurance company's posting of Grant's allotment letter, despite the letter having been lost in the mail. Okay. Okay. Alternatively, of course, if the insurance company's advertisement was specific, which is what Tim was talking about, to the number of shares it had available for the public, it might be deemed to be an offer, in which case Grant's application through the mail would be an acceptance, and Grant then will have to pay for the $400. Okay? Because this is an introductory course, you will not get more difficult than this. If it was something in law school, I will show you the advertisement. You will actually see an advertisement, complete advertisement, and then you have to go through everything to see what they are doing, whether they are excluding the postal rule, whether they are saying there's a certain number of shares, how much you can apply for, and so on and so forth. Have a look at this question, question 4 from page 738. So this is one of the online chapters. I'm not going to go through it. I'll leave it to you. Question 4, 738. Let's jump to page 259. So now we are working on the stuff we looked at today from chapter 9. It says Peter and Mary were engaged to be married. Prior to the marriage, Peter agreed to make Mary a dress allowance of $1,000 a year, again, to be paid in quarterly installments of 250. Okay. So can you recall the case we just discussed that has something very similar to this? We are on chapter 9. Yeah, chapter 9. Which case was it? Yes, thank you. So open the page on page 247 and let's look at it together so we see the differences and similarities. Peter paid the allowance for the first 3 years of their marriage. Then he stopped. After Mary had separated from Peter, she sued to recover the 4,000 areas of the agreed dress allowance. Do you think she is entitled to recover the money? So how do you go about analyzing this question?
Well, it said that he's. Well, I guess the agreement was made. The agreement was that he would pay the dress allowance $1,000 a year and a quarterly thing of $250. But since he paid it for 3 years of marriage, shouldn't he only have to pay an extra $1,000?
Okay. So sorry, you're doing a great job, Luke, but this is not how to do it. Okay? If you go and start writing like this in the exam, you're on your way to failing that question. Always remember there's an analytical structure. This is a question that talks about contracts. As we will see at the very end, when we finish everything, you have to go through every element. Not necessarily talking about every element, only those that raise issues. We'll come to that. Here you start looking at whether there's an agreement. Okay? Is there an agreement? Are we going to look at offer and acceptance? Not necessarily. You can see from the facts that you are told that there's an agreement. They agreed. So that's not really an issue. Then you go to intention. Did they intend for this agreement to be legally binding? That's what we want to talk about. What did we learn today? There's always those two chopsticks. So one way is what we call social agreements. The other way is what we call business agreements. The social agreements, we said there's a presumption. The presumption is that there is no intention to be legally bound, to protect this social relationship. You can rebut this presumption if you give the court evidence to show otherwise, that you intended to be legally bound. The onus here is going to be on Peter or Mary? Mary, okay? The plaintiff. Other chopstick. You have the business arrangements. We said under business arrangements, we have a presumption, what? That there is an intention to be legally bound, but still you can rebut that presumption by telling the court that there's evidence to the contrary. And the onus again is on the plaintiff. So, in this case, do you think she is entitled to recover the money? What's the default position? Is this a social arrangement or a business arrangement? Social arrangement. So you'd say this is a social arrangement. Why is it a social arrangement? Because these promises were exchanged when? We're engaged to be married. So, a social relationship. So, there's a presumption they did not intend this to be legally binding. Okay. Anything now that you can cite on behalf of Mary that can rebut this presumption? Can you convince the court, but based on these facts, can you see? On these facts, they intended this to be legally binding. Mary should get money and recover whatever he did not pay. What do you think? Anything here that you can cite to help Mary rebut the presumption? Yes?
I guess I have questions about the marriage agreement.
Yeah.
It's,
Yes?
does that fall under contract at all? something different.
So it's not the marriage agreement we're talking about. We're talking about the allowance agreement.
Yeah, but depending how the marriage agreement was set up, was agreed to or written or signed, could determine whether
Okay.
that could-
So you're saying that maybe the marriage agreement, which is going to be in writing and signed, might have something to do with this allowance agreement. Okay. What else are you going to say? So what did we talk about when we talked about that Pratt case and the 50 Shades of Grey? What did we say there? We said that this agreement has to be what? You have to look at what? Are we told more than just that there's an agreement? Did they seek legal advice? Do you know? Is that something you need to know? Is that something you're going to tell me about in the exam? Yes. So you're going to tell me, I don't know. Maybe there was a legal advice. Maybe it was in writing. Maybe there were witnesses. Yeah? Maybe. Okay. So, something like this. Again, we start with the presumption. So the issue, I should have put that up there. What's the issue here? Whether Peter and Mary intended to be legally bound. That's the issue. So you start with the law. You remember ILAC? The law. Generally, in domestic agreements, the presumption is that the parties do not intend to be legally bound. However, the presumption may be rebutted if evidence can be produced. Cohen and Cohen, which is a similar factual situation, the court concluded that the parties had never intended to create legal relations, and so it would seem unlikely that Mary will be able to recover the 4,000 ayars in this allowance. If after separation, Peter had agreed, remember separation, when we talked about separation, but they are not living together, the de facto, which case was that? Shortall and White. If after separation Peter had agreed to continue to pay the dress allowance as a form of maintenance, a different result may have been reached, because they made the agreement when their relationship was not social anymore, because they separated. Okay? They would be talking to each other at a different level. In such a case, there would be a new agreement, and the court would be prepared to enforce based on the post-separation, what we call novation of the original agreement. Okay? Remember this word novation? Park it for now. We'll go and talk about it when we end up this analysis, which is chapter 16, when we talk about discharge of contracts. All right. Okay, that's the end of our tutorial for today, and we'll continue on consideration in Springfield. Thank you.